Mr. Attorney, is it your responsibility to ask for declarations of conflict, or have I done that, in fact, by asking you?
Do any members on this committee have any conflicts report on an item on the agenda? I see none, so let's move forward.
All right. Awesome job, Mr. Attorney.
Thank you, sir.
Comments? Anybody from the public that wishes to say anything? Seeing none, then public comments are closed. Let's move on to action items. Approval of summary minutes. Do I hear a motion for the...
to approve.
Mr. Gonzalez, motion, seconded by Mr. Walters. Thank you. Okay. I guess all in favor? Aye. Motion's approved. Approval of Treasurer's Report. Okay. Any board members have any questions? I've reviewed it actually this morning with our staff and Marie, and we're projecting consistently month over month, and our revenues are better than we predicted, and consistently better month over month. So the one item I think that you'll see sticks out. If there is an item that sticks out, please ask any questions. If not, then may I ask Marie, do you have any comments that you wish to make or any questions from the board?
Mr. Treasurer, the only comment I have is that on our traffic component of the toll and fee revenue, traffic is trending about 4% above the forecast, which contributes to the positive variance on the revenue side. We've collected about $9.5 million in fees. We do have an outstanding receivable year-to-date, about $30 million for toll by plate. I do expect, as you indicated, there's nothing really on the expense side that is noteworthy. Overall, the total expenses should be somewhere around 2% below the budget by the time we close the fiscal year. So I think they're very positive results for fiscal 16.
Okay. Any questions from our board members? Okay. All right. Let's move on to then item C, and that's 2016A toll system refunding revenue. This endorsement of resolution.
Before.
Yeah. We need a vote on the Treasurer's report.
Yes.
Okay.
Second.
Okay. Moved by Chairman Martinez, seconded by Mr. Gonzalez. Thank you.
Before we move forward, Chair Martinez, do you have a conflict with anything on the agenda?
Not today, thank you.
Good catch, Mr. Attorney.
Thank you. All
All right. Item C, Series 216A toll system refunding revenue bond. Endorsement of resolution number 16-22. Is this Marie? Would you be taking that?
Treasurer, this is resolution 1622. This is the endorsement of the refunding of bond series 2006 remaining outstanding. This will be series 2016A. These are the same documents that the board approved in, I believe, April of 2015 for series 2015A. We were monitoring that transaction. The governing board did approve it to move forward. Again, we're bringing this item back to this committee. It will. We're looking for a 7.5% refunding savings. We do have a recommendation from Randy Topol, who's our financial advisor. We also have Bond and Disclosure Counsel here today to answer any questions the committee members may have.
Any questions from our board members?
Marie, just one question. What's your overall, if I may, Mr.
I recognize you, Mr. Martinez.
What's your overall opinion of where we're at this time financially, based upon the reports and everything we've received? How are we doing?
You speaking of this transaction or overall financial health of the organization?
Health of the organization.
Overall, I think we're in a very good position. We've done very well this fiscal year. Our traffic and revenue has outperformed. With that said, as you've seen from the strategic work program, we do have a lot of unfunded projects, so we're going to have to manage our finances going forward. Very positive results, but yeah, we do have some unfunded needs that have not been addressed at this point.
Very good. Thank you. Thank you, Mr. Chair.
And please note, this is our last meeting of the fiscal year, correct? Our last budget?
Yes, sir.
All right. So just making sure we're closing out the year in a healthy manner. Okay, so back to the endorsement of resolution number 16-22. Seeing no questions from our board, I guess motion to move.
I think it was moved and seconded, we just need a vote. Correct? I moved it, I believe, earlier. We just need to move,
Okay. That was
I'm sorry,
the
I'll
one I
move this
thought.
one as well. I apologize.
Thank you, Mr. Chairman. I thought I was losing my mind there for a minute.
That's an entirely
I was more
different
concerned about that,
conversation.
but yes, I may be. That doesn't. You're right. So all in favor of resolution? Ms. Weinberg moves it.
Second.
Second by Chairman Martinez. All in favor?
Aye.
Okay. Motion approved unanimously. All right. Now we're discussion items. Presentation by Sandy McClellan. Did I get that right? Federal Securities Law Training. Board members, Ms. McClellan is here today in partly due to a requirement for us for some training. And this is training that is for our benefit, and it is required of the state that we learn a little bit more about some of the things that you have to say. So with that, I turn it over to Ms. McClellan. Thank you for being here.
Before, Mr. Chair, this is unique training, bond training, but also for the attorneys in the room, there's going to be another pass out, a sign-in sheet, and you will be able to get a CLE for the training. I don't, in light of my conversation before we started, I don't know if this qualifies for lobbyist training. I know that you have to go through a myriad of training, but
I don't believe we have any lobbyists. I know we have several governmental consultants here, though.
Except for
Good morning.
Thank you, Ms. McClellan. Morning.
So this will qualify for Florida continuing legal education credit. So if you'll sign in, that would be good. You should have a folder in front of you that includes a copy of the presentation. It also includes.
Okay, there we go. Wow, cool.
Ms. McClellan, excuse me. I want to recognize that we've been joined by Ms. Maritza Gutierrez and Secretary Wolf. Thank you for joining us this morning.
Thank you. So the other two items that are in the folder is the program evaluation, which is required for Florida Bar credit, and then also a certificate of attendance. So those are the things that are in your packet. And if there's anybody in the audience that would like a copy of the materials, they're up here. So thank you for inviting me back. I guess I didn't do that bad of a job the last time, so this is good. I like return engagements. This year's training is very similar to last year's training. There have been some updates, a little bit of streamlining too, because I think we went a little long last time. So we're going to try and keep this on schedule because I know Marie has some videos that she wants to show. So my goal is to be done by 10:50. Is that good, Marie? Okay. So we'll do an overview of regulation, an overview of disclosure requirements. We'll talk a little bit about SEC enforcement, and the last part, which I think is the best, is really talking about what's at stake and what best practices are. So broadly, federal securities regulation is primarily driven by two federal acts. One is the Security Act of 1933, which regulates primary market transactions, those initial sales, and the Securities Exchange Act of 1934, and that primarily regulates transactions in the secondary market. The United States Securities and Exchange Commission was created under the 34 Act to enforce the federal securities laws. The mission, I think it gives you a little bit of insight into where the SEC is coming from if you understand what their mission is and what they think the main purposes of the securities laws are. And so those are included in the materials. The mission is to protect investors first, to maintain fair, orderly, and efficient markets, and to facilitate capital formation. So that facilitate capital formation, that's where public and private entities raise money through public markets. You notice that's last in the mission. So first and foremost, the SEC is charged with protecting investors. According to the SEC, and this is right off their website, the main purposes of the 33 and 34 Act can be reduced to two common sense notions, and that's that companies, and they are primarily focused on public companies as opposed to governments. that are publicly offering securities must tell the public the truth about their businesses and the securities they're selling and the risks involved in investing. And the people who sell those securities must treat their investors fairly and honestly, putting investors' interests first. So that really gives you an idea of where the SEC comes from when they look at municipal securities and governmental entities that are issuing debt in the public market. So the Tower Amendment, this goes back to 1976, which oddly is the year I graduated from high school. The Tower Amendment prohibits the SEC from requiring municipal issuers to file anything with the SEC prior to a bond issue. So public companies that are issuing stock or debt securities may have to file a registration statement with the SEC prior to selling those securities. Municipal entities do not. It also prohibits the MSRB, which is the Municipal Securities Rulemaking Board, from requiring municipal issuers to file anything with the MSRB after the bond issue. So public companies might have to make quarterly reports, annual reports. Under the law, municipal issuers cannot be forced to do that. One of the primary rules that the SEC has promulgated under the Securities Act that affects municipal securities and municipal issuers in particular is Rule 15C212. And through a series of amendments, that has become really the focus of a lot of municipal issuers' attention. And we'll get to more on that later. So, as I said, municipal issuers are generally exempt from registration requirements. They're also exempt from periodic reporting requirements under the 34 Act, but neither are exempt from the anti-fraud provisions in both the 33 Act and the 34 Act. And over the past 20 years, the municipal market has grown significantly. There are some estimates that there are some 50,000 municipal issuers across the country. And that you contrast that with the corporate market, where I believe there's like 15,000 at most. SEC enforcement activity in the municipal market is becoming more frequent and is not limited to investigations after headline defaults. Like the city of New York had a default back in the 70s. That's actually where some legislation where the Tower Amendment was passed. Orange County, California had a bankruptcy. After that, we saw a big enforcement action for that. So it used to be that you really saw significant SEC interest in the municipal market only after there were large defaults, and that is not the case these days. Good morning.
Let me take a quick second. So we want to recognize for the record that we're joined by Mr. Vincent Brown and Mr. Maurice Frey this morning. Thank you, gentlemen.
Sure. So in July 2012, the SEC published a report on the status of the municipal market, and that really sort of lays out where the SEC is going when it thinks about regulation in the municipal market. So things had really been going along fairly smoothly. In a sense, the SEC was really focused on other things. But with the SEC report from July 2012, it's very clear that the SEC has its eyes on improving transparency within the municipal market, improving investors' access to information, improving many things that have to do with transparency in pricing in the secondary market. The report set out a multi-pronged approach, including legislative and regulatory changes, as well as encouragement for more industry-based initiatives. The SEC commissioners have also discussed whether or not that Tower Amendment should be repealed that would allow the SEC to have direct regulation over municipal issuers. So for municipal bond transactions, disclosure is generally divided into two areas. There's primary disclosure. That's the disclosure that you make usually typically through an official statement when bonds are being issued and first sold out into the market. Continuing disclosure is made on an annual or other periodic basis, and that's under a continuing disclosure agreement, which is a contract. That is not, it is a contractual undertaking between the issuer and the beneficial owners of the bonds. For some types of credits, there's also quarterly reporting, the quarterly provision of financial information and operating data. So the official statement is the disclosure document by which bonds are sold to investors. This is important. Primary responsibility for the accuracy of the document lies with the issuer, regardless of who prepares the document. The responsibility cannot be delegated to outside consultants. That includes disclosure counsel. As disclosure counsel, I'm here to assist you in discharging your responsibilities under the securities law. I'm not replacing you in that responsibility. The SEC has said a number of times that the official statement is the issuer's document, and the issuer is responsible for the accuracy of that. It's very similar to a prospectus document a public corporation would issue in connection with stock or debt offerings. So typically, an official statement will include separate sections that talks about the terms of the bonds, the security for the bonds, the purpose for the bonds, any significant risk factors relating to investment in the bonds, who the underwriters are, and financial information and operating data pertinent to the security of the bonds. The official statement will also include a description of the issuer's agreement to provide continuing disclosure. So this is a sample table of contents. This was actually taken from the 2014 MDX official statement. And if you look at the headings, it really gives you an idea of how that document is organized to present information that is important to investors. Your official statement typically includes several appendices, which include the consulting engineer's report, a traffic and revenue study, audited financial statements, the form of the bond documents, and the form of the opinions of counsel, as well as your continuing disclosure agreement. So the requirements for continuing disclosure come from that SEC Rule 15C212 that I mentioned earlier. And except for certain exemptions, it requires an underwriter to verify that you've entered into this contract to provide annual information and notice of certain events. Additionally, the contract has to require that the issuer provide notification in the event that any annual filing is filed late. And the one thing to keep in mind about Rule 15C212 is that it is a rule for underwriters. Remember, I told you the SEC cannot require municipal issuers to file anything before a bond issue, and the MSRB cannot require anything to be filed after a bond issue. But the SEC has direct control over underwriters. So what it can't do directly, it has been doing indirectly by requiring underwriters to verify that certain contractual undertakings have been made by the issuers. Yes? We can do a question now?
Yeah. Go ahead. I would suggest after that, let Ms. McClellan finish, and then we can answer any questions, but we can get you out of here.
Okay. Rule 15C212 requires that all filings with these continuing disclosure undertakings had to be made through their internet-based platform called EMA, the Electronic Municipal Market Access System. It's the official repository for all information about municipal bonds. This information is provided by both issuers and by broker-dealers who are selling those bonds in the secondary market. That part makes it a little confusing sometimes when you look at the information that's been filed on EMA, because it's not clear all the time who filed it, whether it's information that's filed by the broker-dealer or information that was filed by the municipal issuer. Now, the Municipal Securities Rulemaking Board does have a lot of educational materials available on its website, and I think we're going to see a couple of videos that were put out by the MSRB after this presentation. So the continuing disclosure requirements include a requirement that notice be given after the occurrence of certain events, and there's bullet point listing of those events. Most of these are pretty self-explanatory, and you would think as you read through them, well, those would be important to investors. So it's a good thing that this type of information is provided to the market. When you drill down on this a little bit, though, there are some pitfalls, some potholes in the road that particularly when it comes to information that the issuer might not have firsthand knowledge of. We went through a series of rating downgrades of municipal bond insurers in 2008. So one of the required notice events up there are rating changes. So there were a lot of municipal issuers whose bonds were downgraded because their insurance provider was downgraded. And that information, the notice of that change in rating was never provided to the issuers directly. So there were a lot of issuers who missed providing notice of rating changes with respect to their insured bonds. Was that a big problem for issuers? I think the market already knew, the information about the downgrades of the bond insurers was really widespread. And in fact, the market probably knew before the issuers did. Let's see. So let's talk a little bit about voluntary disclosure. Voluntary disclosure is anything that's not required under the terms of a continuing disclosure agreement. So there might be circumstances under which an issuer would want to provide information to the market over and above the required information, and that goes hand in hand with a good investor relations program. For frequent issuers who are in the market consistently once or twice a year, it's good to maintain a good relationship with the investor community, with institutional investors in particular. So when the next time your bond issue comes around, they're very open and welcoming to hearing more information about a new bond issue from you. I can't tell you that I've ever seen a dollar for dollar response from the investor community, but I think I get backup from your financial advisor that will tell you that good investor relations make for good bond sales. So, but it's important to note that any information that you are putting out there to the investor community that is reasonably expected to reach the market is subject to the anti-fraud rules of the Securities Act. That would include information that's available on an issuer or borrower's website that is designed to be providing information to the investment community. I know MDX actually has an investor relations website portion of the overall MDX website. So it's important that information, that you understand what part of your website might be subject to anti-fraud rules, and make sure that the terms of use and the disclaimers that are at the bottom of the website are clear in terms of what the intended use of that information is. So I'm going to talk a little bit about SEC enforcement. So enforcement actions by the SEC against municipal issuers are generally brought under either 17A of the 33 Act or 10B of the 34 Act. You probably heard of Rule 10b-5. That's promulgated under the 34 Act. It's Rule 10b-5 and Section 10 under which a private action could be brought by an investor against a municipal issuer. Section 17 of the 33 Act is it can only be used by the SEC in an enforcement proceeding. The main difference between the two is that under Section 10b and Rule 10b-5, it requires a showing of what we call scienter or knowledge or reckless, significant recklessness. There has to be some level of intent, some conscious intent to defraud. Section 17A of the 33 Act only requires a showing of negligence. And it's really only been in the last few years that the SEC has used a negligence standard in a 17A proceeding against municipal issuers. So what is recklessness? Recklessness has been defined in court cases to be an extreme departure from standards of ordinary care, which represents a danger of misleading buyers or sellers that is either known to the defendant or is so obvious that the defendant must have been aware of it. This slide talks a little bit about who the potential defendants and what the theories of liability and remedies are in an SEC proceeding. MDX has never been the subject of an SEC proceeding. I hope you never are. But the SEC has shown a wide range of potential defendants. They have gone after sitting mayors, finance directors, budget officers, council members, lawyers, underwriters, and pretty much anybody. If there's anybody who is culpable or appears to be culpable or comes within the sights of the SEC has been pretty broad in spreading that net. The theories of liability that they may employ would be direct misconduct or aiding and abetting. So it might not be that you were directly responsible for the alleged fraud. It could be that you, either before or after the fact, were involved. Remedies include fines, injunction, and a bar order. We've not seen too many fines against municipal issuers, but we have seen a few, and the number that they see keeps going up and up. Most of the SEC enforcement actions in the municipal area with municipal issuers usually end with a consented to settlement agreement. So there are very few that actually go to court, although the city of Miami is in the midst of a court battle with the SEC. One of the reasons that that is in court as opposed to an administrative proceeding is that the city of Miami was already under a cease and desist order from the SEC from 2005, I believe it was. And so the SEC is really trying to make a statement with that proceeding that not only do they believe that the city of Miami violated the Securities Act, but they also now have an additional count of violating the original cease and desist order. So that city is defending that vigorously, and that'll play out in the headlines. This is a list of some of the SEC enforcement cases that we've seen in the municipal area. I'm going to speed this up. So one of the things I do want to point out on the SEC enforcement side is that the SEC staff has the ability under the Securities Act to issue what's called a 21A report. This action is used infrequently, but it does express the views of the SEC regarding a particular area or investigation. The city of Harrisburg was the subject of a settlement SEC enforcement action, and after that investigation and settlement, the SEC issued a Section 21A report that dealt specifically with actions of public officials. And that public statements, not just written statements, but the public statements made by public officials may affect the total mix of information that's available to investors, and that those public statements could be subject to the anti-fraud provisions under federal securities law. In the city of Harrisburg, what happened is that the city stopped making those continuing disclosure reports. So there was really no information available to investors through that EMA website on the MSRB. The mayor, however, continued to talk to the public and continued to paint a very rosy picture about the financial position of the city. And those statements were posted on the city's website. So it was sort of like the State of the City address in connection with a new budget. So those statements, combined with what the SEC said were fraudulent financial statements, were all posted on the city's website. And it was that action of posting on the city's website, the SEC said, made it reasonably expected to reach the markets. And it was on the basis of those statements that the SEC filed an action against the city. In that case, they did not file an action against the mayor, but they did issue the Section 21A report as a means to sort of put the information out there that public officials should be mindful of public statements and that they may affect that total mix of information available to investors. So as if an SEC enforcement action wouldn't be enough, the Department of Justice can also has the ability to file criminal charges in connection with a violation of the Securities Act. There could also be state criminal charges. There's also private plaintiff actions under Rule 10b and 10b-5. So the price of failure. So an SEC official recounted the fallout from a San Diego enforcement action with this statement. when you just read down to the dollar amount, the city spent more than $25 million for internal investigations and consultant reports to determine what happened and who was responsible. That's a lot of money. The state of New Jersey settled with the SEC, and this was the New Jersey investigation was not a very long investigation, but as reported in Bloomberg that the city was billed $7.9 million by a New York law firm for legal work on the case. It's costly. I really don't want to know how much the city of Miami has spent over the course of 2 years of defending an SEC investigation, but I'm sure it's a lot of money. So here's my pop quiz. I didn't have this last year. This is new. So the pop quiz. Which of the following could be the subject of an SEC investigation for municipal issuers? Primary offering documents, continuing disclosure filings, audited financial statements, websites, other statements. Very good. You all have been listening. You get an A. It is all of the above. And the thing to remember is that statements made in connection with the purchase or sale of securities, including not only offering documents prepared for the purpose of selling securities in the primary offerings, but also continuing disclosure agreements or any other document that's filed on EMMA. Other statements that are reasonably expected to reach investors in the trading markets, including those on websites and press releases and even in reported speeches, even if those statements are not intended to reach investors. So in order to better manage and hopefully limit legal exposure, many issuers have adopted policies and procedures to assist them in preparing and vetting disclosure. Disclosure procedures can help to reduce the chances of making a material misstatement or misleading omission in disclosure to investors, and it can establish a defense of reasonable care against actions for misstatements and omissions that nevertheless might occur. Best practices. I continue to, the best practices really haven't changed from last year. This is really about developing and implementing best practices and policies, including a process that will make you aware of the events that need to be disclosed. And part of that is the action of designating one or more people within your organization who have that responsibility, training and education for issuer officials and staff, which you all are very, very good at. It is important not to lose sight of the big pictures by letting procedures become, the be-all. It has to be a process that can be adapted to situations at hand. It has to be something that is based on common sense, based on your own process, so that people are more likely to follow it. You have to have the right people involved, the people who have the information that is important to investors. But first and foremost, I think the education and training process is key. And the last point is very important. Take disclosure obligations seriously, because the SEC does. And these are my takeaways. I'm doing good here. Accessing the public municipal bond market through the issuance of municipal bonds results in a long-term commitment to investors regarding certain finance and legal covenants. Utilizing this public bond market subjects the issuer to federal securities laws and the scrutiny of the SEC, and that's for the entire life of the bond issue. Violation of federal securities law, even if unintentional, could result in an enforcement action and significant cost to the organization and potential personal liability to individuals involved in the violation or those who control the person. Responsibility for the accuracy of information released to the market continues for so long as MDX bonds are traded or in the public market. And with that, I would be happy to take some questions.
Okay. Thank you very much. I know you had a question, Mr. Gonzalez. We'll start with you, and any other, Mr. Walters after.
I'm not sure if I have a question for you or staff, but I assume we have a best practices manual on this that's been approved and that we follow in terms of issuing all these?
Bless you. We have a debt management policy, and our policies follow the Government Finance Officers Association, which also puts out practices on how to issue debt and what are some of the requirements for continuing disclosure.
And then the second part of my question was, if we're all liable potentially for things that other people do and that most of us have no idea how to meet the requirements, do we have indemnity from the organization? Do we have insurance to cover potential liability, and how much is that?
I don't know if it's specific to issuing debt, but there is liability insurance on each of the board members as well as the executive team.
But
And
would that liability insurance cover this type of...
That's a very good question. It covers negligence, and it's $2 million per board member, I believe. $2 million
Per board member.
per board member, I believe. Per incident, I should say.
Not per board member, per incident.
Per incident, you're correct. But it's a good question. We should really look into that.
I guess my question to you is that sufficient liability insurance to carry, or because these things are huge. I mean, we just issued $900 million worth of bonds.
Right. So your individual, your personal liability would be limited to your personal actions. So if there were actions or if there was fraud committed somewhere else within the organization, you would not be personally liable for that.
Even if you voted for the issuance of the bond or approved the documents, because in the end, we do all of that.
My best advice to issuer officials who are like approving bond documents is see something, say something. Yeah. Yes, the organization as a whole is responsible for the accuracy of those documents. You as a board member are responsible that if you see something that's wrong in that official statement, that you say something. Orange County, California had a massive bankruptcy issue. Their issue was with their treasurer, who was investing in risky derivative financial products. The Board of Supervisors in Orange County did not know that. They did not understand that that was a risk. They were not held personally responsible because they approved bond issues that had disclosure documents that didn't disclose those risky investments. There was a Section 21A report that was issued after Orange County, which also said that the Board of Supervisors, in approving that, did have a responsibility to report something, inaccuracies in the documents if they saw it. There's a great debate over whether or not individual board members are required or are required under securities laws to verify every single fact that's included in your official statement. So most boards do not.
But I'm not sure you answered the question, and the question is, do you believe that we have sufficient, coverage at this point? I guess because I'm thinking in terms of individually, I understand that could be negligence, could be somewhere else, but then we could be called into an action, and then we would individually be responsible protecting ourselves. Do we have enough coverage, in your opinion, or are we protected enough to be able to?
My immediate response is probably, but I'd be happy to talk with your general counsel about that.
All right.
I will follow up with the Florida League of Cities, verify that, number one, that it is covered. Number two, what our coverage is, and discuss it with Marie and Sandy.
Would you make it to come back to us in the next, budget and finance meeting? All right.
Absolutely.
Mr. Walters, you had a question? Did I? I'm done.
And to date, the fines that I have seen levied, I think the only fine I've ever seen levied against a sitting board member was in like the $10,000 to $15,000 range.
But it's also the process of getting there.
I agree.
And not to mention, as volunteers, we need to protect ourselves.
I agree.
Walters?
I'm assuming that an integral part of what we do before we issue bonds is look at our revenue consultants' estimates on how much money is going to be coming in. But if they give us bogus information, we're still responsible for that.
Well, let's talk a little bit about historical information versus forecasted information, because there are two different things. Your historical information needs to be accurate, and yes, you are responsible for that. We put a copy of the traffic study in the official statement. The assumptions that drive that forecast are included in the official statement. I think as an organization, you have a responsibility to review those those assumptions and make sure that in your mind those assumptions are reasonable. But you're not required, or you're not responsible for that forecast to come to fruition. So it is a forecast. There's a disclaimer that's in the OS that says anything that says expected or anything that's based on a forecast is not guaranteed.
Well, the reason I'm asking that is this past Sunday in the St. Petersburg newspaper, there was above the fold, big front page article about revenue estimates for a proposed toll road in the area. And it really blasted the consultant that was responsible for doing these estimates. And it's a name we all know. And basically said it has a track record across the country of, overinflated estimates and whatnot. And I was reading the article. I was very smug. These guys really have a problem, not like us, until I turned the page and saw a picture of our director, which made me focus on the article. It referenced our consultant as also having similar types of issues nationwide. And I would like some kind of assurance, I guess, that our estimates are okay.
Yeah, Board Member Walters, as we discussed yesterday, the context of the story was about a particular project in Central Florida and Tampa Bay, the TBX. There's a lot of people against the TBX. The reporter made a series of calls to people around the country with general questions. And here was the general question he asked. And he asked me. He says, would you agree that if your traffic and revenue numbers are off, that is a problem? I said, yes. But those traffic and revenue numbers have certain assumptions. And those assumptions, the owner has to participate actively. You cannot expect not to be participating in actively putting assumptions, then criticizing the outcome. The owner has a particular representation. The obvious story was blasting the TBX. And he took mine, he took Joe Wagner's, and he took several others to highlight those instances where traffic and revenue forecasts have been off, significantly off. But in each one of those cases, if you were to do some research, you would find that either the owner or a combination of owner-consultant didn't look at all of the assumptions and validate them. I can clearly and confidently tell you that at MDX, we actively, proactively participate not only in the assumptions, but in validating the assumptions, understanding what happens so that we can forecast correctly. And our historical numbers prove that out. So,
Mr. Ferre?
Yeah, and the proof of the pie is in the eating. In other words, I think our record stands pretty clear. But in Colorado, there have been several failures. I think Illinois also has had failures. The failure of a bond issue in an expressway authority is very rare. What, 3 or 4 such examples in the last 10 years? Is that correct? Yeah. And in those particular cases, I think there were some very good reasons for these failures, and it was really based on erroneous thinking. We have 5 roads. I mean, with all due respects to our expert and the people that come here and tell us, what's going to happen, these are not greenfield projects. These are mature projects that have a track record, and the track record is pretty consistent and constant. I mean, for there to be a failure on our part, something very, very, very outstanding would have to happen.
The majority of examples that are cited in the article, Mr. Walters and board members, where there is a 20 or 30% off, are typically greenfield, as Mayor Ferre said, where development is going to be here, development is going to be over there. We want a toll road to go through. The development doesn't get approved. What did you expect? I mean, that's typically what happens. That's where they cite those types of examples.
Just one
follow up, and then Ms. Weinberg.
Yeah, just one last follow up. Cliff, I think the Tampa situation is based. That's a bold move on Joe Wagner's part. I mean, they want to go 16 miles, and it's a very controversial area. The Tampa Bay area has a long record of resistance of putting any dedicated source of money for transportation. They want transportation, but they want somebody else to pay for it.
Okay. Ms. Weinberg?
Just a question, and it touches on Mayor Ferrer's point on failure on our part. I wanted to clarify, because I believe I heard you say when it comes to liability and culpability on us as a body, the FCC did not find that our reading of the document was our responsibility. Did I hear you correctly?
I'm talking about individual board members.
Yes, individual board members. When it comes to the negligence, is
They
the
stopped
reading,
short of that.
So,
They stopped very short of that.
But it was
right. So as an organization, the organization is responsible for the accuracy of the document. Typically, and this is very typical, the organization delegates the authority to prepare and develop those documents to its staff.
Okay.
And the SEC does recognize, although they haven't put this in writing, they have said this at numerous panels, they recognize that delegation is done, and for the most part, it's the way it should be done, because the staff is likely to be more in the knowledge about the operations, the day-to-day operations of the organization.
yes, and there's therefore delegation that comes with a great trust placed on your
Correct.
staff.
Correct. So you might imagine a situation. It's not a panacea. You don't get to say I'm on the board, so I'm not responsible. You do have a responsibility as a board member. If you do read that OS and you do see that there's information that's incorrect, or you read the financial statements for that matter, and you see that there's information that is incorrect, you could be responsible for that information. It really all truly depends on the facts and circumstances around that. If the SEC believes that you have guilty knowledge or that you have acted improperly, they will find a way to attach liability to you.
Okay, thank you.
By reading is key.
Any additional questions from our board? Okay. With that said, I want to thank you, Ms. McLennan. We
Thank you.
appreciate the explanation and the ability for us to get educated on some of these matters. Okay.
I just want to, for the record, it is 10:50.
Right. Okay. I guess now Marie, we're going to talk about the municipal securities rulemaking.
Since we approved the bond series 2016A, I thought it would be, as a refresher, to just show a quick video. It's 3 minutes about the issuance process, which I think might be helpful to answer a lot of questions.
When a state or local government decides to issue municipal securities to finance a public project, it typically will hire financial professionals to get the bonds into the hands of investors. These financial professionals include securities firms known as underwriters, as well as the use of municipal advisors. The state or local government initiates the process of hiring an underwriter, either by selecting a firm or sending a request for proposals to a number of firms in the case of a negotiated offering, or by accepting bids more broadly for a competitive offering. Once selected, the underwriter acts as an intermediary between the state or local government and investors by agreeing to purchase all the bonds from the government and resell them to investors. The underwriter assumes financial risk when purchasing all of an issuer's bonds. As such, underwriters often share this risk by forming groups or syndicates. The underwriter and any syndicate members are in an arm's length relationship with the state or local government. The underwriter's incentives are to earn a profit selling the issuer's bonds, and they have financial interests that differ from those of the state or local government issuer. Underwriters are required by law to act fairly and not engage in deceptive or dishonest practices with either the issuer or investors. During a bond offering, state and local governments may also hire a municipal advisor to provide financial advice and represent their interest in negotiations with the underwriter about the structure, pricing, timing, and distribution of the bonds to investors. Unlike underwriters, municipal advisors have a federal fiduciary duty to their government clients and are required to act in their best interests. When a state or local government issues bonds, it typically prepares a document known as an official statement that explains the bond's features and characteristics. The official statement is the issuer's document. The state or local government discloses in the official statement important information about its financial health and ability to repay the bonds, as well as a description of the key features of the bonds themselves. The underwriter either provides a copy of the official statement to investors purchasing the bonds or provides information on how to access a free electronic version of the official statement on the Electronic Municipal Market Access, or EMMA, website at emma.msrb.org. When the bonds are issued, the issuer also signs a so-called continuing disclosure agreement, committing to make available on the EMMA website certain annual financial information and other ongoing updates. These ongoing disclosures inform both investors and the marketplace about the issuer and its securities and support transparency. Once the bonds have been sold, the state or local government deposits the funds into an account for safekeeping until it is time to pay for the project. The Municipal Securities Rulemaking Board regulates underwriters and municipal advisors, promotes municipal market transparency through its EMMA website, and provides investors and issuers with objective educational resources to help them make informed decisions. For more information on the MSRB and access to up-to-date resources, visit the MSRB's website at www.msrb.org and the EMMA website at emma.msrb.org.
Marie, do you have any other comments or statements that we need to?
I think, we have throughout each of our budget and finance meetings continue to educate board members, refresher. We have new members and so forth. We do have $1.5 billion of debt outstanding. So it is important, I think, to go through this process. The upcoming refunding, we will put out a schedule within the next 2 weeks as far as when pricing will occur. I believe Randy gave an update at the last budget and finance. We were somewhere around $20 million present value savings. $21 million. So we'll continue to update our board members on that issue.
Is there any questions from our board members for Marie or staff in general? Okay. Thank you, Marie. Thank you. Let's continue with our informational items. You'll have some, handouts that have already been provided to you.
Yeah, a lot of the handouts support the video and the presentations that we heard before. It's just information for you to take.
There will be a pop quiz at the next budget and finance. With that said, any comments to the good of the order? Not, I move to adjourn before our 11 o'clock Operations Committee. Okay. Move. Second. We stand adjourned. Thank you all.